Should be good to go. Going to check and see if the systems are running here. Yep, it's like we're good. All right, so it is 11 o'clock, so let's get started. Welcome everyone to docket 6680 DR 114, the petition for declaratory ruling and complaint of WPL against Scenic Rivers Energy Cooperative. It's concerning electric service extension. This is Michael Newmark, the Administrative Law Judge for the PSC. We're connected through Zoom, and we have the parties and commission staff in attendance. We've invited members of the public to attend to observe the hearing through Zoom. But we do not have any members of the public in attendance at this time. Okay, we're gonna have to just go off the record for a minute. I'm gonna just pause this for a sec. I need to take this call. Okay. Well, we're gonna go off the record for a second. Yeah, we're back. Sorry, I had to take that call. I had my we're actually conducting this hearing from a hospital because my mom's in the hospital, so I just had to take a call from her doctor. We've been waiting to hear from him. So, all right, let's get back on the records. Apologize for the interruption there. So we have we know where we're at, and we're just going to take appearances on the record. So let's start with the PSC.
Evan White appears on behalf of the Public Service Commission, Wisconsin.
All right, and Scenic River.
James Woywood of Frederickson and Byron appears on behalf of Scenic River Energy Cooperative, SREC.
Right, and Wisconsin Power and Light.
Good morning, Your Honor. David Zappo from Hush Blackwell on behalf of Wisconsin Power and Light Company.
Okay, thanks. Okay, so for the usual drill on pre-hearing conferences, looking at parties, schedule issues, facilitating matters. So we sent out the notice of pre-hearing conference with the draft of what we're about to determine here. First of all, we know our parties. So I just have on the screen share petitioner and respondent. I did indicate in this kind of newfangled table here the acronym that we can use or we should use as the party identifier for filings. So when you're doing your direct party name, witness name, just want to use that acronym, and then we'll all be standardized right from the beginning. So hopefully we won't need to make any corrections for that. So, are these acronyms okay with parties?
It's fine by us, Your Honor.
Okay.
Yes.
Okay, great. And the issue, these are fairly standard for territorial dispute cases. So I just have that to display it on the screen share. Any comments, questions about the issue?
None from WPL, Your Honor.
Okay.
Nothing from SREC.
Yeah, and I should mention that I think parties and staff have discussed this proposal and basically came to agreement for most of everything. I think there's just a few date questions that I had, and I did indicate the hearing date was a little different from what parties agreed to at May 21st for the party and public hearing session. And actually, my schedule may not permit that anymore. It's the one that I thought I was being able to make. And I guess I was going to propose either, they're doing in-person. This is just being very tricky to me. If we did an in-person hearing, we'd probably need to go to a week. And let's see, so I'm not sure how this would pan out with the rest of the schedule, but I think I could do Zoom hearing on the 20th or the 21st. But for in-person, well, 20th is a little tricky. I try to avoid hearings on Mondays just because filings are coming in, people are just getting oriented again on the case. So if we can avoid Monday, that would be a good thing for everyone concerned. But in terms of Zoom hearing, I think the 21st will work. But for a in-person hearing, 17th would work, or a different week probably we need to go to a different week. So I'll be out of the country. Let me just take a look at that. Yeah, out of the country for the week and week of the starting the end of the evening of the 21st, and then through the next week. So I don't know if people have comments, and that looks like surrebuttals do the 10th. So there's probably some leeway to make a different date for the hearing if we wanted to do it earlier. So any suggestions on that front? I can just...
Your Honor, I think you mentioned the 17th for in-person. If WPL's preference is still in person, the 17th works on my schedule. I would just follow up with our presumptive witness, following the today's hearing to confirm, but I suspect that would likely work.
Okay,
Or
and
at least
then
be available either in person or remote for that witness.
okay, and then since Sir rebuttal's due on the 10th, we really have that week, as you can see here, that week is actually pretty much free of events, hearings. So any, Tuesday through Friday, we can do the hearing. So I don't know if Attorney Zappa, you have an opinion on which day?
Your Honor, I think the 17th would work. I would
Okay.
just like to check with my client, Zach Ramirez. I believe he had some travel scheduled around this time. I'm not exactly sure. So I would just want to verify with him. But I think that's better than pushing it into June, the 17th. Yeah.
Yeah. All right. So we'll set it tentatively for the. Oh, sorry.
Sorry, I didn't mean to interrupt. Did you say that? So we're looking at any time that entire week potentially for in-person hearing?
Well, like I said, I'm trying to avoid Mondays, but 14th through the 17th would work.
If we could do one of those other days, that would be preferential for me, or I guess the morning of the 17th, I could maybe work. I have some travel for that weekend, so.
Okay. Sure. So, well, can we try the 15th? And you probably need to check back, but if we send it tentatively for the 15th and then just check back with us.
Yes, Your Honor. I can. I think the 15th would work.
Okay.
And again, yeah, I'll check with my client, but I think that'll work.
Okay. So we'll do so we will take public comments as well. Usually for these kinds of hearings, we just combine those events at the same time. So we'll just break and take comments if there's anyone in appearance on. I'm assuming they'll probably be on Zoom, but we'll make the hearing location available to the public as well. It'll be in our Madison office in the hearing room.
And for sorry.
Yeah, no, go ahead.
I was going to ask for the 15th. I assume we were looking at a morning start, but
Sure.
did we want to identify a kind of a presumptive time?
Yeah, 10 a.m. Start at 10, unless you got some conflicts. Try to at least give more time for the hearing than less, since there's no conflicts during the day. No other hearings scheduled, so we don't have to work around anything else. Okay, so we'll say 15th on the 10th for now. 15th, May 15th at 10 a.m. And looks like we'll just have to just change that errata date for if we just do it on the Monday. What is that? 13th for errata. Okay. And besides that, I think we have our facilitating matters. See, this one's dated January 16th, so it's been in place for a while. We're still trying to make updates, but I'm not including those more recent ideas in this. They haven't been fully formed yet, so we're not going to test you out too much with new things. This version does have an interesting twist that you may not have encountered yet, which is for a while we've been trying to get parties to eliminate hyperlinks in testimony and exhibits, either to disable them by well, it's complicated. You don't have to know that anymore. So you don't have to do disabling links anymore. But what I'm asking you to do is, see, for testimony, it appears on page 4. If there's a link, you want to disclaim at that point, maybe a footnote, that the information contained is not record evidence. So solely based on the offer of the link, you're not offering evidence for the record. Then actually you can call it NRE from that point on. If you have more of those, just put the NRE acronym in there. And you can always, refer back to this document when I finalize it. And then for exhibits, it's similar, except you just need to put that disclaimer on the cover page of the exhibit. And then inside the exhibit, you don't have to disable links. You don't have to eliminate them somehow or redact them. Just leave the document as it is. I'm not exactly finding the place for that right now, but it's in there somewhere. I think it's this number 2. Any information contained in a citation that appears in this document based solely on that citation is not record evidence. So trying to make things, that's supposed to make things easier. So we'll see. We'll see how that goes. We've been successful in the last case. So any questions about that? No. Okay. And any other questions about facilitating matters? No.
Actually, Your Honor, and this may have just been a product of how we presented the schedule to Mr. White's. I know we typically have filings on testimony at or before 1:30 p.m. and I didn't see that addressed separately in the facilitating matters.
Yeah, you're correct. So that's not in the proposed schedule as listed, but yeah, the deadlines for filing will be 1:30 p.m. Yeah, thanks for bringing that up. The other thing I was curious about is the stipulated facts. We will have the documents, the petition and the response documents. They need to be offered for the record. So they'll have the stipulated facts document and those other 2. We've had some issues in the past, especially when parties are filing direct at the same time, that they'll offer all those documents on their own. So we'll have duplicates. So why don't we have, instead of doing it that way, we could have the petitioner complainant file the petition and complaint as an exhibit, and the respondent file the response as an exhibit. And to make it easier, we could just have those exhibits just be named EX, WPL, and petition complaint, and EX, SRCE, response. And then they'll just be easy to find when we list those out on the evidence list. Otherwise, the stipulation of facts, that should also be an exhibit. I don't know how parties want to do that. We could probably have the petitioner file that once it's, if it's agreed to, and just call that the same, in the same vein, EX, WPL, stipulated facts.
Yeah, Your Honor, that works for WPL.
Okay. And how many witnesses are we expecting from each side?
For WPL, I don't think we've made a final decision, but I wouldn't expect more than 2 to 3 witnesses.
Okay.
And for SREC, at this point, anticipating 1 witness.
Okay. Okay. So the way we're planning it, it's perfectly okay to do that, but the SREC witness will be on Zoom. We're sure of that. And are we expecting the WPL witnesses to be in person or be connected?
Yes, Your Honor. At this point, we're expecting our witnesses to be in person.
Okay. All right. It's good to know.
And Your Honor, it may be that the witness is able to be in person, but basically wanted to reserve the
Sure.
ability to have their remote.
Okay, I understand.
Thanks.
All right. Anything else we need to cover? No?
Nothing from WPL.
Nothing further from SREC.
All right.
Nothing from staff.
Okay. Well, thanks very much, everybody. Take care. And so what I'll do is I'll I'll hold off on the order, the pre-hearing conference memo until we just get back confirmation on the hearing date, and then I'll issue that. So in the meantime, just go with the schedule as we've discussed in the today at the pre-hearing. All right. Thanks very much. We're adjourned.
Thank you.
Thank you, everyone.
Take care.
And good luck to your mom.
Oh, yeah, thanks. Oh, I thought I cut everything off. Okay, didn't do that yet. Yeah, thanks. Hopefully, well, she'll be in procedure few hours, so hopefully everything will go well.
Okay. Well, I'll say a little prayer for her. Take
Yeah,
care.
thanks. Appreciate
All
it.
right.
Okay.
Bye-bye.